Right, well, thank you everybody for coming. It's an absolute pleasure to have Justice Teresa Doherty here from the Special Court for Sierra Leone. Now, many of you will have seen the flyer which describes her absolutely distinguished background as an international jurist and a jurist of all geographies, as you will no doubt have noted. But I'm sure you are far more interested in hearing what she has to say, but very briefly, she became a Supreme Court judge in Papua New Guinea, the very first female to sit in that country, and no doubt prompting a revision of gender roles in society, something I'm sure Justice Doherty will speak to in terms of the role of the Special Court, the expressivist role that the Special Court has played in prompting revision of attitudes towards gender and the role of women in society in that country and the greater region. So, of course, then subsequently she became a judge in the trial chamber at the Special Court for Sierra Leone. Court for which its final case, that of former Liberian President Charles Taylor, is now before the appeals chamber, and I believe we're hoping to receive that decision sometime this year. Although, yeah, these anticipated deadlines must inevitably missed, it seems. But without further ado, I'm sure you'll all join me in welcoming Justice Teresa Doherty to the Auckland School of Law. We very much look forward to your presentation.
Thank you very much. And I must say it's an honour to be back in New Zealand, a country that I've always admired for its jurisprudence and its lead in many things to do with human rights and international rights as well. Sierra Leone, as Mr. Mahoney has said, had a court, and that followed a civil war there. Sierra Leone itself is a very small country, West Africa, bounded by the Atlantic Ocean, Liberia and Guinea. It is rich in natural resources, rutile, diamonds, marine resources, and like many countries that are rich in natural resources, they can be a curse as much as a benefit. From approximately 1991 to 2002, its population was subjected to a very brutal civil war, the hallmarks of which included killing, sexual violence, amputation of limbs, the burning of villages and communities, and the abduction of children by the warring factions to be what are become known as child soldiers. I personally have been involved in the fallout of 3 civil wars, or disputes or conflicts or whatever you want to call them. And what always strikes me from that experience is how different the causes of each of those conflicts was and how differently each government handled them. Sierra Leone's civil war started as a protest against internal political corruption. Its leader or leaders joined other people involved in the Pan-African movement, which was partly financed and promoted by the late Gaddafi of Libya. The Sierra Leone leader of the student faction in Libya, a fellow called Ali Kaba, according to the evidence we heard in the Charles Taylor case, by one of those ironic twists that you have in anti-corruption cases, took the money and ran. The thousands donated by Gaddafi have never been seen before, have never been seen since. We don't know where he went. And his role was taken over by a man called Fodi Sanko, a former photographer and corporal in the Sierra Leone army, who very safely from a long distance ran the Revolutionary United Front and the civil war in Sierra Leone that followed. His number 2 was a man called Sam Boukary, who never made it to the special court because he was killed and, according to the prosecution, eliminated by Charles Taylor to avoid him giving evidence. Certainly he was killed, but we made no finding as to why he was killed. But his proclivities or his personal aims in life were to be a gigolo and a hairdresser in Paris. And he ended up being one of the most vicious killers that I've ever heard of. In any event, the fighting that started the civil war in Sierra Leone was a protest against internal political corruption. It started in the east of the country, and like many civil wars and civil disputes, it was far away from the capital, and the politicians didn't really care. So it was the people in the provinces that were suffering. No great action was taken at the beginning, and it wasn't until the invasion of Freetown, the national capital, in 1997, that the realization that we have a terrible civil war on our hands really hit home. And again, by one of those ironic twists, Freetown is so named because that is one of the places that the liberated slaves from America who had fought in the American Civil War on the side of liberation were repatriated to. And following the peace declaration, the last peace declaration, there were a few, as often happens in civil conflicts. The government of Sierra Leone negotiated an agreement with the Security Council of the United Nations to set up a war crimes tribunal to try those responsible for the crimes committed in the course of the conflict. The Security Council had already said and expressed what they said was a very deep concern at the very serious crimes committed within the territory of Sierra Leone against the people of Sierra Leone and the United Nations and associated personnel, and the prevailing situation of impunity. They particularly stressed what they called the widespread and egregious sexual violence against women and girls. As a result of that treaty between the United Nations and the government of Sierra Leone, a tribunal that became known as the Special Court for Sierra Leone was entered into, and the court was set up, and that was signed on January 2002. That special court was the first of the treaty-based hybrid international war crimes tribunals. Its mandate was more restricted than those of the Yugoslav tribunal or the Rwandan tribunal, and its powers were limited to try those who bore what the statute called the greatest responsibility. Now, the other two ad hoc tribunals had Chapter 7 powers, which meant that they could order a country to give assistance or find witnesses. Special Court did not have that, and its responsibility, as I said, was restricted to those who had the greatest responsibility. Something that was followed in Cambodia, which had a limitation to those who bore the most responsibility. So there was a restriction, and as you can imagine, it led to all sorts of arguments about what was the greatest responsibility. That really old defense that I've heard since I can remember, it wasn't me what done it. It was the other bigger boy. He came along and he what done it, not me. So that was one of the first arguments as to what that jurisprudence of responsibility. It was the first of the tribunals also to include as a crime in its statute attacks on peacekeepers. And that was an interesting development because one of the things that happened in the Sierra Leone Civil War was the abduction of 500 peacekeepers from the United Nations. That also led to the intervention by the UK to liberate some of their peacekeepers. Interestingly enough, they did not include attacks by peacekeepers on the civilian population. And that was an issue that was really made a lot of by the defense in the Charles Taylor trial. They produced film and arguments saying that peacekeepers were attacking civilians. Why are they not being charged? Why are they getting this special status? And when you look at, for example, news reports about Darfur and the actions of peacekeepers, yes, it's a valid question. The agreement between the government of Sierra Leone and the United Nations also included for the first time domestic legislation in the statutory powers of the court. It included laws relating to abuse of girls under the Prevention of Cruelty to Children Act and malicious damage. But in fact, none of the persons that were charged by the special court were ever charged under the domestic legislation. So how it would have gone in an international court, I can't say. There was also special provisions for who would be appointing the judges and the prosecutor. It was divided between the government of Sierra Leone and the United Nations. And interestingly enough, the government of Sierra Leone initially appointed non-citizens and only one citizen judge at the beginning. The court sat in Freetown, Sierra Leone, and it was the first international war crimes tribunal to hold its trials in the country or the place where the alleged conflict took place. I'm a big believer in having crimes hearings in the place they happened, and it was one of the things I did in PNG was to try and get out to the area, because one of the big arguments is justice has to be seen. And if you're sitting in a foreign country and in a foreign or in another town, the local people aren't seeing what's happening. So when the Charles Taylor trial was transferred from Freetown to The Hague, I personally was one of the people that wasn't very happy about it. Not that anybody was interested, in my opinion, of course. The decision was made in New York and they couldn't give a what I thought about it. But it was quite interesting how the local perception was of that transfer. People said, oh, they've taken Mr. Taylor away and he's going to die in a foreign country. Why? Because Milosevic had been taken from Serbia and died in The Hague, and they reckon this was going to be what happened. And it's, as an aside, I haven't got this in my notes, by the way, but as an aside, there was one occasion during the hearing when Mr. Taylor's lead counsel, Courtney Griffiths, was unwell. He was diabetic and therefore had to be careful. He was unwell, and junior counsel stood up and said, sorry, Mr. Griffiths can't be here today, he's got food poisoning, and we sought an adjournment, so there was an adjournment. Liberian West African headlines in the newspapers were attempts to poison the Taylor's lead counsel. So this is how perceptions occur. The government of Sierra Leone also set up a Truth and Reconciliation Commission and to consider and to report on the causes leading to the civil war and to the events which occurred during it, and to make recommendations. The secretary to that commission was Professor Bill Shabbos of what was then the Galway School of Human Rights, and a leading human rights international lawyer. That mandate included investigating the extent and of the breaches and the violations, and to promote healing and reconciliation. That was part of its mandate. It also sat in Freetown, and its hearings were contemporaneous with the special court. My feeling when I read about it long before I became associated with the court was that there could be a conflict between a court and a civil TRC, a Truth and Reconciliation Commission. But in fact, they worked together or contemporaneously without any dispute or conflict. The local perceptions sometimes mixed them up. Local people sometimes mixed up the Truth Commission with the court, but on the whole they worked well together. They made some very good recommendations and some findings, one of which I totally agreed with because I was at first a judge in the national jurisdiction of Sierra Leone. I went out there at the request of the Commonwealth after the war, and the Truth and Reconciliation Commission found that one of the contributors to the civil war was the inability or the possibly corruption of the local judiciary. And I had to really agree with that. I was truly shocked when I went there as a judge and saw personally how a lack of judicial strength and a lack of judicial will can be a major contributor to abuses of human rights. And the failure of a judiciary to protect the ordinary people from the executive was a very much contributing factor in the Civil War. The initial group that started the Civil War in Sierra Leone, as I said, were the Revolutionary United Front, locally referred to as the RUF. And in time, the Sierra Leone army, who were supposed to fight them, also had a coup and joined with the RUF to fight the government. Already it was thought that some of the army were already fighting or making use of the Civil War for their own personal benefit to loot. They became known as Sobels, soldiers by day and rebels by night. And people couldn't understand what these rebels were. And stories used to go around, are they like a monkey with things with tails? What are rebels? Because, again, there was just a total lack of education, a lack of awareness in the capital to what was happening in the provinces. The opposition of the Armed Forces Revolutionary Council, which was the group that had the coup, who joined the RUF, to the government, led to the promotion or the setting up of a group of traditional hunters and fighters who became known as the Civil Defence Force. Their aim was to repel the rebels, and they also got, at the end of the day, those three groups, the leaders of those three groups, and Charles Taylor, who was then the president of Liberia, the neighbouring country, were charged by the prosecutor of the special court for war crimes, crimes against humanity, and breaches of international humanitarian law. There was a total of 13 indictments against 13 men. They were all male indictees. There were no female leaders of any of the rebel groups, although definitely women did fight. And it was acknowledged that one of the failures of the peacekeeping by the United Nations was its failure to involve women in the post-conflict reconciliation and peacekeeping. And that is a theme, again, that recurs in other conflicts. Certainly in Northern Ireland, that was a major failure on part of the British government to forget of the role of women in peace negotiations and peace keeping. These 13 men were 12 individuals in Taylor, with the Civil Defence Force, who included a Deputy Minister of Government. And of those, 2 died before coming to trial, one from natural causes, that is Fodi Sanko, the leader of the RUF. The other was Sam Bokery, the erstwhile gigolo who became the leader of the fighting leader of the RUF. And a fellow called Johnny Paul Koroma, who is still at large and, depending on who you listen to, is either alive or dead. initial indictment included, as I said, an indictment against Charles Taylor, the then sitting head of state. That immediately led to the first of the challenges to the jurisdiction of the court. And he challenged the right of any tribunal to indict a sitting head of state. At that point, he was still head of state. It led to a decision by the appeals chamber, which sat basically like a constitutional court on interpretation of the statute, that said that there is no immunity from prosecution for a sitting head of state for war crimes or crimes against humanity. And that was the first international decision that said sitting heads of state are not immune from prosecution. And it has led in turn to indictments, for example, against al-Bashir of Sudan and possibly Kenyatta of Kenya. But that was the first case. It was quickly followed by another challenge when the Deputy Defence Minister was arrested as being a leader of the Civil Defence Force, that said there was an immunity from prosecution for war crimes or crimes against humanity because in one of the peace agreements, the Lome peace agreement, it included an indemnity from prosecution by those people who had fought in the rebel forces. So they said, hey, we made peace. Part of the peace agreement was that you wouldn't prosecute us. That's why we made peace. Hey, what are you doing now? And again, the appeal chamber looked at that situation and again ruled that an amnesty in a peace agreement from prosecution does not include an amnesty against war crimes and crimes against humanity. In any event, of course, they had broken the peace agreement, but that was a corollary to the matter. That again has led to one of those continuing disputes that I don't think are new at all. What comes first? Is it peace or justice, and can we have both? It's the argument that is being used by Kony in Uganda. Why should I give myself up when you're going to take me to The Hague and the International Criminal Court? I'm not sure what the answer is, and I'm not going to speculate because I'm not a politician. But I do know that both are important. And Northern Ireland, of course, did have a lot of draconian laws leading to, at the beginning, to internment, holding without trial. They learned the hard way that that's not a sensible approach. And eventually they did have an amnesty of sorts and released people from prison. Papua New Guinea had nothing in Bougainville Civil War of that type. But it again is an example of how governments handle these problems. But it is very much not just a theoretical problem, but a real one too. So those were the first challenges. We then went into hearings. And as I've said, the preliminary report of the government and the United Nations spoke about the widespread violence against women and girls. And they particularly, as a result of that, there was a provision in the Sierra Leone statute that provided for qualified persons dealing with sexual violence crimes, prosecutors and investigators, and also to deal with juvenile justice. One of the hallmarks of that conflict was the use of children in war. The modus operandi for child soldiers, as they became known, was to go into villages, round up the population, kill some of them as an example of what happens if you resist, abduct the able-bodied and particularly the young women and publicly rape quite a lot of them as an act of terror, and take children and the able-bodied away. The able-bodied to work, children to be trained as child soldiers. They were often given drugs, usually by cutting the head and rubbing the drugs in. And one young child soldier described in evidence, he said, "I went crazy, I didn't know what I was doing, I was mad, my eyes were red." And this gave them extra bravery, and they would be sent back to deliberately kill members of their own family. And once they did that, that meant they were alienated from their community and under the control of the leaders. That led to the first, in the statute, to, as a breach of international humanitarian law, the use of children under 15, the recruitment, conscription, and use in armed conflict of children under 15. That again was challenged as a preliminary challenge to the jurisdiction. It was said there was no such crime that was recognized in international law. And again, the appeals chamber, acting as a sort of constitutional court, had to consider that. And they looked through international treaties, international norms, international conventions, and they came up with a decision that use of children had been maybe not always against international humanitarian law, but they were able to pinpoint a point in history when it had become part of the international humanitarian law, that you could not use children in armed conflict. One of the leading points in that was the Convention on the Rights of the Child. It was not a unanimous decision, it was a majority decision. One of the dissenters was Judge Robertson of Australia. But it involved a review of human rights treaties and norms. And that is where I then looked when it came to forced marriage. Where do you get your international law from? You don't, as we say in Ireland, scrape it off the wall. It has to be somewhere. We, like any national jurisdiction, are bound by the jurisprudence, the legislation that is there. We don't make it up as we go along. Gerald Wehrle, a German writer, has set out at great length the idea that, and so has Justice Kenneth Keith from New Zealand, you do not make up international law any more than you do not make up national law. That comes from a legislative body. And Wehrle says you look at international conventions, international treaties, international declarations, plus national law. And he says it's universal national law, Islamic, civil law, common law, Hindu law. When I came to do my dissent on forced marriage, I tried to look at every continent and take a legislation or a case law from every continent, including Islamic and Hindu. And I was able to find it. So that is child soldiers then became recognized as a breach of international humanitarian law. But that did not stop the old argument. You are a foreign court, you are imposing foreign rules on us, the defense lawyers said. They said, and we were the court that I sat on, the trial chamber I sat in, I sat on the Armed Forces Revolutionary Council case. There was 3 of us, a judge from Samoa, who from this part of the common law jurisdiction, and a judge from Uganda, and myself. And we were the first trial chamber to deal with child soldiers as a crime. And one of the arguments that came up at the end, not during evidence, which was one of the things that annoyed me, came up as the sort of the last minute in submission, was, we are an African court. African children do not have a recognized age of majority at 15. African children traditionally work and fight, and you cannot come in here and place an arbitrary limit of 15 years and say that it was a crime for us to have our children. My little brother came along with me to this war, you know. He just liked to come along with me and help me carry my gun, was one of the arguments we heard. You cannot impose this form against traditional custom. And I can remember being, I wouldn't say annoyed, I suppose I was a bit annoyed that why after 18 months of evidence are you suddenly coming up with this theoretical argument now? Why haven't I got a bit of evidence to provide this? But it reminded me of the attitude in the national court system of, if I mentioned an international treaty, particularly the Convention on the Rights of the Child, and I would say, look, Sierra Leone was the 7th country in the world to sign the Convention on the Rights of the Child. Why can I not consider it in this court case? And it was like, you know, a Greek chorus. The lawyer stood up en masse and said, we signed it, but we haven't ratified it. It's nothing to do with us. It's not like that. Your country signs it, and this is where countries like New Zealand and Australia and Canada have led the common law world in saying, if you sign a treaty, even if you have not translated it into domestic law, you should consider it when interpreting your law. So this was the argument I used, and I remember saying to this lawyer, you are asking me as a judge to recognize rights for the children of the world, but not the African children. You're asking me to go down on record as saying there's one law for African children, but there's protective law for all the other children in the world. Not in my court. I'm not going to make such a ruling. So we not only said that there is a crime, but when it came to interpretation of the terminology use of children, which was not defined, we looked to the evidence and found how wide use is in a war. Because those children were not only used to carry guns and to fight and to kill, and in particular to cut off arms. That was their forte. They were also used to scout. They were sent out to go into villages and check out what was happening, to bring messages, to convey information from one group to the other, because these rebels would be often in isolated places. And their main source of information between each other was the BBC Focus on Africa programme, which they checked into at 5 o'clock every afternoon to find out where their fellow rebels were. And sometime when all of this is over, I'm going to write to the BBC and tell them about their contribution. In the meantime, the trial we were in, the Armed Forces Revolutionary Council, also brought in 2004, before the trial started, the prosecutor sought to amend the indictments to bring in a new crime, or a new count rather, not a new crime, a new count of forced marriage. The court had already charged the indictees with sexual slavery and rape. Rape was, as I said, on a mass scale, recognized by the United Nations. One of the very alarming aspects of civil conflict is the attacks on women. It's an act of revenge. It was also considered the spoils of war, as one writer called it, an entitlement on soldiers. But right through conflicts, although there have been some in court cases following court conflicts, that was never raised. Not even in Nuremberg, not in Tokyo. And despite the fact that actual sexual violence was part of the Tokyo crime provisions, but nobody was ever charged with it. Nobody was ever charged with it in the ICTY at the beginning. When was it first charged? Not even by a prosecutor in Rwanda. It wasn't until Judge Pile, on hearing evidence, said, well, why isn't this rape in this indictment? And that, in the Akayesu case, led to an amendment of the indictment to include sexual violence. But the special court, given the history of sexual violence, was the first of the courts to actually put it in its original indictments. Of course, now it is common in the Yugoslav tribunal. Even it's been considered in Cambodia as a unique case. I'll not go into that. But the prosecutor sought to amend the indictment to include that. A very interesting review of the history and the reports on sexual violence and conflict was set out in the dissenting opinions of Justice Boutte, who was a judge dealing with that amendment application. It was allowed in two of the cases, the Armed Forces Revolutionary Council and the AFRC. Goodness, I did that case and it's jet lag, sorry. Led to that being put in. Boutte said, among many other things, it is clear from the material gathered in the preliminary reports, that's that of the Special Rapporteur on systematic rape, sexual slavery, and slavery practices in armed conflicts. He said, it is clear from the material gathered in the preliminary reports that there exists a very substantial body of international law relating to systematic rape, sexual slavery, and slavery right practices during wartime, including internal armed conflict. And that was a particularly important aspect because Sierra Leone was an internal armed conflict, not an international one. And one of the other arguments that we had on jurisdiction was, this is not an international forum, this is an internal conflict. You lot cannot come in from outside and interfere with our internal jurisdiction. Again, doesn't apply to international crimes against humanity and war crimes. So he recognized that, and it led to the amendment of the indictment, and for the first time a count of forced marriage went forward in two of the trials. And again, we were the first court to deal with forced marriage as a crime against humanity. The evidence showed that women and girls, as I said, were forcefully taken. They were marched, they were brought back to the camps, and they were allocated. There was even in one of the camps a registration system where the men had to sign for whatever women they got. Women could be either married off or told they were the wives of leaders. The youngest girls were given to the small boy units, the child soldiers, and the better looking and the young women to either commanders or to just any ordinary soldiers. Women that were not allocated to specific men were free for any man to take. And one of the awful pieces of evidence I remember hearing was a man describing his niece being gang raped after she was abducted until she died, and then her body was thrown into a pit with others. The women that were allocated were wives. Being a wife meant that they had to look after the husband's property. They had to bear children and look after it. They had to do the washing and cleaning and some of the cooking. and they had to carry the goods that were looted from one area to the other. They were not obliged to fight, and if that husband had any status, they also had a status. So wives of leaders were actually given young children who did their cleaning and looking after them. They were given a title. They didn't and they sometimes had power, for example, to distribute looted goods that were looted from villages or towns. When it came to the jurisprudence and the decision, the majority in that trial said there was no difference between sexual slavery and the situation of these women, even though they did have a particular status, etc. I dissented on that, and I wrote a separate opinion saying that there was a different situation, that these women were subjected to mental and not just physical but mental suffering because they had a status forced upon them that meant usually they were unable to go back to their communities. Once they were considered the wives of these leaders, their own community said they were tainted and they could not return. So a conjugal condition was enforced upon them. They were considered wives. Once the husband got fed up with them, he would get rid of her and take on somebody else, and usually eliminated them by sending them to the front to fight. If she transgressed, they were very severely punished. But if he transgressed, there was no form of punishment. And when, again, as in child soldiers, I looked very closely at the international norms, the international decisions, and in the end, that dissent was upheld by the appeal chamber, and also the dissent on sexual slavery, which the majority had said was bad for duplicity. And the appeal chamber said the victims were subjected to mental trauma by being labelled as rebel wives, and they were stigmatized and found it difficult to integrate into their communities, causing mental and moral suffering, which in the context of the Sierra Leone conflict is of comparable seriousness to any other crimes against humanity listed in the statute. When we come to those, a court's obligation, to my view, is to give a fair hearing and a reasonable time. Did we contribute to reconciliation? I suppose we did. I think we did. It wasn't my job to find out. But the special court had a very wide outreach, an outreach that has been used as an example for the International Criminal Court. It went out into the communities. It spoke at schools, it spoke in halls, it spoke in any form of community area. And as a result of that, there was more known in the community about the work of the special court than in the other tribunals. They tried to educate the people about what they were doing and why they were doing it. That outreach has led to much of the acceptance of the special court and the acceptance of its decisions. In contrast to what has happened in other places, when that deputy minister who was charged, Hinga Norman, died of natural causes in the course of his hearing, there wasn't the riots, there wasn't the outrage that I would have expected from in other communities. The Sierra Leoneans were accepting of what happened. They were accepting of the decisions. Have we confronted immunity? Well, I'm a bit cynical about that. Yes, we have said there is no immunity if you're a sitting head of state. You cannot pretend that you are immune because you're a politician. What is the outcome? As I've said already, al-Bashir in Sudan has been indicted by the International Criminal Court. Where is he? Well, he's still actually in Sudan. And what's he doing? Well, he's not doing anything about the war crimes in Darfur. That I do know. So, has it been translated into a practical application? Not so sure. I think my conclusion might be, when it comes to politicians, they're like any other form of criminal. They think they're going to get away with it like any other shoplifter, speeder on the road, or regular burglar. They didn't notice me that last time, they won't notice me the next time. But at least the special court has shown that it will catch up with him. The other thing I do feel is that we have shown that there is no immunity automatically because of peace treaties. Again, as I've already acknowledged, that has led to conflict and dispute. And there is no immunity because your custom says children under 15 can work, or your custom says that we have worked, despite the criticism of anthropologists and writers who have said judges don't know custom. They don't understand. To which I have said before, I haven't said to Tim Kelsall yet, when he said judges are ignorant of custom. I don't know who you asked, Sonny, but you didn't ask me. And if you had, I would have told you, you have got one of the customs wrong. So I would say, special court, we didn't achieve everything, but we did achieve some things.